Good day, everybody. I am so excited to start the 2021 training sessions. And I'm particularly excited about the way we're doing it this year. I am very sorry that I'm not doing your trainings live as I used to last year and the year before and all the other years. But unfortunately, turns out the whole cloning thing didn't work out so well. So there's only one of me. And this is the reason why I have opted for this new option of doing training. So I am pre-recording these sessions. So I'm doing one recording and then sending it out to everybody that I'm training. And as you know, many of you, I will have live Q&A sessions later, but please forgive me for doing the same session for everybody. On that topic, I do want to make mention of something quite important. Going through the training sessions for the entire year, it could very well happen that I make reference to clauses in a lease agreement. And everybody that knows me and that's been through my training would know that the lease agreement I'm referring to is the residential TPN leaseback lease. And it might not in your life look like a TPN lease because it will probably have your branding on it. But as you know, I'm the drafting attorney of the particular lease agreement, together with a few other attorneys that help me to make sure that we really put the best possible lease agreement out there. So when I do make reference to a clause in a lease agreement, it will be that particular lease. And if you know that you are on that lease agreement, even if it's your group branded lease agreement, you will quite comfortably go to that clause and see what reference I'm making. If not, you're more than welcome, obviously, to get your hands on the TPN leaseback lease in the TPN shop. And you are welcome to follow me. I'm going to try and avoid it as far as I can to keep the training as general and standardized as possible, simply because I think everybody knows I'm a big driver towards industry standardization when it comes to rentals, and it's for this exact reason that I can do trainings like I'm currently doing for everybody, where I'm recording one session and I can cover training for many different agents and many different groups of agencies. So that's just a little quick background disclaimer from my side. But for everybody that doesn't know me, I am Silna Steyn. I'm the Managing Director of SSLR Incorporated. SSLR is a specialist eviction firm. And well, I just said eviction firm. I mean, a specialist property law firm, but with a strong focus on evictions. I suppose that's the standard thing that will come out of a rental orientated firm. So I'm very excited to start the training sessions this year. Today's particular session, I'm trying to keep relatively short on time, simply because I know many of you need to rush out to go do an inspection or a viewing or whatever the case might be. And we don't really have time to sit behind our computers all day and watch attorneys tell us, all sorts of boring things. I do hope that I won't bore you at all, but I want to get into it. The way we've planned the training for this year is basically on the back of last year. I've seen what kind of questions comes up, and I want to make sure that as we go through the year, I cover the questions, I cover the things that you might stress about, because the truth is, as a rental agent, you are dealing with a very complex part of the law. And if you are comfortable with the particular part of the law that you are dealing with, when an agent or a landlord or whatever asks you a question, you need to be able to jump to an answer quite quickly, either in your lease agreement or through the trainings that I'm doing for you. And the reason for that is obviously the quicker and more effectively you can answer a question, the less time you spend on it. And the truth is, what we want to do is keep you guys out of the tribunal and away from the EAAB, and make sure that you don't end up spending all the time in disputes between landlords and tenants. but you are actually able to get out there, list more properties and place more tenants and build your book. So this is the reason for the way we've set up the training sessions for this year. Everything is already pre-planned. And if you have any suggestions or recommendations, more than welcome to pop me a mail and let me know about that. But I do believe in our training sessions planned for the year, we will cover most of the pressing issues that you might have encountered in the past, or for that matter, encounter as we go through 2021. But so welcome and thank you so much for joining me, and let's get straight into it. If technology will work with me, it's already a fantastic place to be. All right, like I said, SSLR Incorporated is a firm committed to extraordinary excellence in property law. And I do believe all the viewers and all the agencies that I work with, every agent that I work with, is typically also committed to extraordinary excellence in property law. So I hope as we go through the year that I will add to that, and that I will add value and make your lives a little bit easier when it comes to rentals. So for today's session, I've decided let's do a general session, a bunch of Q&A stuff, questions that I've had during the past year, things that tend to create some drama for the typical agent. So let's see if I can tackle a few of those, really unpack it, so you get a start in the year already, ready with some answers to questions that might hit you during the course of the year. When we talk about 2021, I think there's still a lot of people that's surprised, even towards the end of February already, that 2021 turned out to not be a completely different landscape from 2020. I actually thought this is a funny way to start a training session, to say that there was 2020 and all the drama in 2020, and then just as we thought from about October 2020, things seem to be looking up. On the 28th of December, we were surprised with lockdown level 3. I'm recording on today's date is the 16th of February 2021. And I just had a look at the government gazettes, and obviously at this stage, the national state of disaster has been extended to the 16th of March 2021. As we've seen from the past, these extensions tend to happen. We will now officially extend to the 15th of March 2021, and that is, yes, even on lawyer mathematics, that is exactly a year since the original declaration of the national state of disaster. We will probably remain in a state of disaster for the foreseeable future. And with that in mind, I think it's important to appreciate that life isn't back to normal, and I can't see that life will go back to normal ever again, because what is normal even? But currently we are in lockdown level 3. We might go back to level 2 or 1, or well, at least the way our numbers are looking at this stage, we will probably not go back to level 4, but we might remain in lockdown level 3 still for quite some time. Why I'm mentioning this is, as I do training and as we progress through the year, things will change, and we will again go to different lockdown levels. And as we've seen with lockdown level 3, just as we were used to lockdown level 3 last year, lockdown level 3 this year is different. And we've had a change in the middle of lockdown level 3 around the regulation. It's very important for us as players in the rental game to really understand the lockdown regulations. For us, the most important ones would be Regulation 37, prohibiting evictions unless it is done by a competent court. What does that mean? Well, guys, Surprise, fun fact. This is no different from Section 26 of the Constitution, which has been in part of our law since 1997 on promulgation of our Constitution. Section 26 of the Constitution says that no person may be evicted or have their property demolished without a competent court granting an eviction order after the relevant circumstances has been taken into consideration. Now, Regulation 37 of the current lockdown regulations specifically deal with that and says no person may be evicted, wait for it, unless a competent court granted an order for eviction. Okay, so this is no different from the days before COVID was even a term in our lives. It's really nothing new. Only trick is, in terms of Regulation 37, a court may suspend execution of the eviction order unless the court is convinced that it is just and equitable to execute that eviction order. Once again, crucial to use a specialist eviction firm when you're doing an eviction, because we now know exactly how to plead it. We've been doing evictions all the way since the 1st of May 2020, also successfully executing them. So there's no reason to believe that evictions cannot be done during lockdown level 3. Very important to know this, because I've seen, unfortunately, tenants using this as an excuse not to pay rent, where actually there's no reason for a tenant at this stage not to pay rent. If a tenant is not paying rent, even in lockdown level 3, you must definitely, if the tenant didn't pay on time, the first day following the non-payment, you need to do a letter of demand, allowing the tenant either 20 business days, if Section 14 of the CPA applies, or which other time period the lease agreement agrees to, should Section 14 of the CPA not apply, to remedy his breach, and only if they don't remedy the breach, then that lease agreement can be cancelled and we can commence with eviction proceedings. So nothing different, except for Regulation 38. Regulation 38 is specifically dealing with residential property and the Rental Housing Act. So in terms of Regulation 38, there is an obligation on a landlord and a tenant to have a meaningful engagement, trying to meet each other halfway when it comes to rental that cannot be paid as a result of the effect of COVID. This is crucial because Regulation 38 now makes it an unfair practice for a tenant and a landlord, both of them, not to engage each other when there is a problem when it comes to payment. What does this mean for you? This means if there is a tenant that hasn't been paying rent, and you pick up the phone and you say, "Hi, Mr. Tenant, seems like you haven't been paying your rent. Don't you please, want to tell me what's happening in your life?" And he refused to talk to you. He is guilty of an unfair practice in terms of the Rental Housing Act, meaning that should you then in future try to seek an eviction order and he raises some or the other dispute, you do have the right to say, "But wait a minute, this tenant is guilty of an unfair practice simply by refusing to engage the landlord when we tried to resolve the issue." This is the case for the landlord as well. So landlords and agents, if a tenant tried to engage with you and say, "I can't pay my rent because I was retrenched, because my company closed down because of the results of COVID," and the landlord and the agent simply refuse to communicate with the tenant, this could create a big problem. Engage means not say, "It's fine, you don't have to pay rent." Engage means put the landlord's story in front of the tenant as well. "Yes, Mr. Tenant, I am really, really sorry, and my heart breaks for you that you've been retrenched. But the landlord is a pensioner who's reliant on this rental income to survive." Put that in writing and bring that to the court's attention. Because when we are doing evictions, we are putting very strong emphasis on the personal circumstances, not just of the tenant, but of the landlord as well. This all plays into the principle of Ubuntu. Ubuntu is a principle in our law that says all people are required to see each other as human beings. Let's quickly pause and consider that. If a tenant sees the landlord as somebody who has very deep pockets and you can live in his property for free, he doesn't see the landlord as the person. He doesn't see the landlord as the single mother who had to move in with her parents and rent out her own house to be able to take care of her children. You just see the landlord as a faceless entity. The same goes for a tenant. If you just see the tenant as somebody that's not paying the rent, you might miss the part where the tenant is somebody who was recently retrenched as a result of COVID, potentially lost a family member and a lot of money for hospital expenses because a family member contracted COVID and passed away accordingly. I know I'm being extremely dramatic now, but bear with me. The reason why I'm being dramatic is these are the stories that's real and that's happening currently. And if we don't tell the court our stories, the court can't make a ruling that is actually just and equitable. So please keep this correspondence in writing when you are trying to engage with a landlord or a tenant. Keep it in writing, or for that matter, do it over Zoom or Teams or whichever one of the platforms that we have. Arrange a meeting that you can record, because if you can then demonstrate to a court that the parties try to engage with each other and one of them were just like, no, thank you, I'm not paying, or no, thank you, I don't even want to meet you halfway. It makes it much easier for us to tell the entire story to the court. So keep this in mind. Lockdown level 3, no different from lockdown level 2 and 1 that we've seen towards the end of 2020. The regulations around eviction and rental property is actually pretty much the same as it used to be in lockdown level 2 and 1. What's going to happen in the future, I can't tell you, but luckily, like I said, I will be here to bore you monthly with a training session, and I will keep you updated as we progress through the year. So, what does 2021 hold for rentals? I have no idea. I think everybody is hoping for an answer around when will things return to normal? When will the property industry be back to where we were? I don't think that's a conversation we can have unless you have a crystal ball and you know exactly what the future holds. What I can say is the agencies that I've been working with all the way from not just 2020, but even before that, I have seen agents come up with amazing strategies in a very difficult time, reinventing what they are doing. And I think it's crucial to appreciate that what we've learned as a rental industry during 2020 is amazing. And we will be stronger for it in 2021. I have no idea what's going to happen in 2021. We could have a further third wave of infections. We can go back into a more strict lockdown. We have no idea. None of us know what's going to happen. And I suppose this is why it's important to appreciate that as long as there's this risk of COVID flying around and going back into lockdown or not, it's essential for every landlord, tenant, and agent to cater for a situation where we could go back to a more strict lockdown situation. So, what does this mean for agents? We've seen amazing things. We've seen people getting very creative with digital signatures on lease agreements. We have seen creative ways of resolving issues, inspections and viewings and things like that virtually and in person, but with one person staying outside of the property, the other party going in. It's very exciting to see how things are changing. I know it might not be exciting every day, and very often it's just scary and frustrating. but I think we are going to be better for this. I think 2021 might be another difficult year. I think it would be silly to think anything else. But I think it's important to know that rentals will remain rentals, and people will need accommodation, and nothing is going to change except for the constant change that we need to get used to, and that 2020 taught us. So nothing in the bigger picture is going to change. The rentals will remain part of life, and probably so will COVID. So why I'm saying this is it's important for us to have continuous updates on what is happening around us. And we create platforms for this. I think over the past year, more and more people realize that it is so important to spend some time and educate and train and give a little time so everybody is updated. One of the big things that we've done in 2020 was forming the Property Law Alliance. Many of you know about this. So on Facebook, there's a page, the Property Law Alliance, a group and a page. And what happened is during April last year, full lockdown last year, I approached a few other eviction specialist firms, and I was lucky enough to have two other firms join SSLR to form this Property Law Alliance. This is Bruno Samau attorneys, as well as Vermaak, Marshall, and well-beloved with the well-known eviction specialist attorney Greg Vermaak. And the three of us, Bruno, Greg, and myself, joined forces to bring free weekly question and answer sessions in the form of a webinar, the Wednesday webinar, every Wednesday evening at 6 on the Property Law Alliance page, where you can post a question and we will argue it out. Sometimes it gets exciting because picture 3 eviction specialist attorneys in one webinar arguing with each other. It can get quite entertaining. And the reason why I'm mentioning it on this particular platform is the continuous questions we're getting from our viewers, and our viewer base is growing on a weekly basis, and excitingly, organically so. We've never advertised at all. And the reason why it's growing is people are desperate for information. So use these things, use the training sessions, and you are obviously always welcome to go onto our website, sslr.co.za, read the articles that we are posting, follow us on social media, watch the Wednesday webinars every Wednesday at 6 on the Property Law Alliance page. Get the answers and know what's happening, because things are currently changing so fast. It feels like we're playing an old school video game where things are like hitting you from all sides. As long as you know what's happening, it should be easy to navigate around it. But that was me on the intro of today's session. Let's get to the actual questions that I want to unpack a little for us today. First one, variation to a lease agreement. Amendments to a lease agreement. How should this be done? In specifically the TPN leaseback lease, there is a non-variation clause. This is a very standard clause, and it will be in most lease agreements. I really would like to encourage you to go and fetch your lease agreement, pause the video. This is the joy about not having a live session. Pause the video quickly and go and grab your lease agreement. Go through the lease agreement and see if you can get your hands on the non-variation clause of your lease agreement. It will typically read something like, no additions, amendments, variations to this agreement will be valid and of any force or effect unless it has been reduced to writing and signed by both parties. Why this is a very relevant part of your agreement is, if that clause isn't there, any verbal variation, any indulgence, anything could actually change the content of your lease agreement. Problem with this is, if something happened, for instance, there was a telephone call to the landlord to say, listen, I can't pay on the 1st of the month, can I please pay the 15th? The landlord said, perfect, no worries. And eventually, the tenant doesn't pay, and that provision falls in dispute. The only way we can prove that is by leading oral evidence. Now, most of you who's been in my training sessions before would know that I always say, we want to bring an eviction application, not on action. Quick for you with the law here. You have two options of getting a matter to judgment. On the one hand, you can issue a summons. If the summons gets defended, that matter will go on trial. In trial, you can lead oral evidence. On the other hand, you have motion process. This is where your application starts with a notice of motion and a founding affidavit. That process only happens on paper. So no oral evidence, and it's simply affidavits that gets filed. You can do this if there's no potential factual dispute in the particular matter. So if the parties are saying, this is the lease agreement, here's my non-variation clause, whatever anybody says outside of this agreement is irrelevant to my life, because we have the intrinsic evidence rule in our law, which says if you have a written contract, nothing outside of that contract is relevant to your life in any way, shape, or form. So I don't care how many witnesses you have saying that the parties agreed to something. In terms of our intrinsic evidence law, you can't bring that to the bring that as a defense and ask for oral evidence to be led to show what the parties agreed to, except because this is the law. They always say lawyers study 1 year to get the rules and then 3 years to get to the exception. So yes, the exception, if you have an agreement that doesn't have a non-variation clause, it does open the door for the risk of a variation in terms of a verbal variation or something outside of the agreement. And in that particular case, the court must allow that evidence to be brought before court, and that will have to be on oral evidence. So why am I now so opposed to oral evidence and not taking matters on trial? Because it takes too long. A trial in our magistrate courts typically going to take you about 12 to 18 months. A trial in our high courts, most of our high courts, you won't see the inside of the court on a trial in less than 2 years. It is a very long time. I don't want an eviction to take that long. On application, unopposed, depending on the court, you can look at about 2 to 3 months. If it becomes opposed, once again, depending on the court, probably going to be about 6 to 8 months, unless there's something super weird or the court is very congested or whatever the case might be. But it's a much quicker process. So a non-variation clause in your lease agreement is not just essential for not confusing the parties. A non-variation clause is essential so we can get to court as quickly as possible if we have to do an eviction. So if there is an amendment, how should it be done? Well, by an addendum. As part of your documentation, there will always be a standard addendum to a lease agreement. An addendum is simply a document that now forms part of the lease agreement where the parties agree to whatever in writing and both parties sign it. Once again, if you have a proper drafted lease agreement, your lease agreement will allow for counterpart signature. So the tenant prints and signs and scan and email it to the agent, and so does the landlord. And even though you have two separate documents, it is read as one document. So let's take the example of the tenant that can't pay on the 1st of the month, but now he changed jobs and he's only getting paid on the 15th. The clause in the addendum will simply say, the parties refer to clause X dealing with the rental payment and the payment due date. The parties agree that the tenant will not be paying rent on the 1st of the month, but as of the 1st of March 2021, the tenant will only be obliged to pay his rent by the 15th of every month. Bam, Bobby's your uncle. It is really that simple. Both parties sign, and there you go. please make sure you don't conclude anything unless it is reduced to writing and signed by both parties. Otherwise, it will have no bearing or effect on your lease agreement. Unless, again, you do not have a non-variation clause, please go check and make sure you do have one, because as nice as it sounds to sometimes be able to make an arrangement over WhatsApp, it could blow up in your face much worse than the effort to quickly do an addendum to the lease agreement. Then, next question is, what is the validity or the enforceability of arrangements that are made verbally or over email or WhatsApp? So this is arrangements. This is not variation of the agreement. This would be something, for instance, I am the agent and I send a message to the tenant. Good day, you are moving out in 2 weeks. Can we please arrange that I come and inspect on the 28th of February at 4 in the afternoon? Tenant replies and says, yes, I am happy with that. You get there and the tenant isn't there. Have you now complied with the provisions of the lease agreement as well as the provisions of the Rental Housing Act requiring the landlord and the tenant to make arrangements in advance with regards to the inspection of the property? Have you complied? Have you not? Is a WhatsApp written notice or not? Well, this is going to depend on the content of your lease agreement. In most cases, written notice will be in the form of digital or digitally reproduced or handwritten notice. So in most lease agreements, and I would prefer it to be that way, something like a WhatsApp or an email would not be a valid written notice. So if the lease agreement says written notice, this will not be sufficient written notice. Usually an email. If the parties in the schedule of the lease agreement include an email address, an email would definitely be seen as written notice. Why I'm worried about WhatsApp and verbal agreements, it's once again proving that that party was actually the party sending the message or talking to you over the phone. What I suggest is, if the arrangement is done over WhatsApp, please just follow up with an email. So send an email then to the selected email address as recorded in terms of the schedule of the lease agreement and say, as per the WhatsApp conversation today, I will be there at the property at 4 in the afternoon on the 28th of February to do the inspection. Never, ever, this is a little tip, little Valentine's Day gift for you guys. And now by the time you watch it, it's far from Valentine's Day, but bear with me. The little gift I'm giving is, if you end your email by saying, kindly confirm that this is in order, you open yourself for a dispute. Simply state what the parties agreed to and end it by saying, kind regards. Never ask for confirmation of receipt. Never ask for confirmation of correctness of the content. If you are doing an email, and this is now just for a fun fact, if you are doing an email where you want the tenant to confirm something, confirm, or the landlord, write everything in the email and say, kindly inform me as soon as possible or within the next 2 days, whatever the case might be, should I have recorded any content incorrectly. So never ask a party to confirm the correctness. Ask them to tell you within a certain amount of time if you've recorded it incorrectly. Why? Because if somebody wants to play a game with you, they're not going to confirm this with you. If you put a deadline on it and you give them a time period to tell you if you've recorded something incorrectly, and they don't, it means by definition and by their omission of communication, they agree that your version and recollection of the entire thing was correct. So make sure you do that. Avoid verbal and WhatsApp communication, or these days, I mean, after the whole WhatsApp, Facebook, Mark Zuckerberg drama, there's a lot of people currently on Signal and Telegram, whatever. A lot of things. I've seen a lot of people communicating over Facebook Messenger or Instagram Messenger. It's all good and well, but it is not necessarily legally binding. So make sure you confirm whatever you agree to in an email to the email address that the parties agree to in terms of the lease agreement. Then let's move to something even more entertaining: maintenance and occupation. What is occupation? I have seen, especially over the past year, especially in commercial retail properties, that there's this weird perception that unless you are physically with your body in a place, that it's sort of deemed to not be in occupation. Now, the truth about occupation is occupation doesn't have to be with your own body. It could be your stuff. And I'm sorry I'm using the term stuff, but I can't find a better word in my brain right now. If your chair and your bed and your microwave is in a place, you are in occupation of the place. But all the way back from Roman law, we have different ways of delivery. And you have something like delivery with by giving something which will then mean you have delivered. For instance, if you deliver the keys to a property to a tenant, he is then in occupation. And he may move in, but the fact that he doesn't mean he's not in occupation. In residential, we don't often see the term beneficial occupation, but what we do see is an occupation date. And this is an amendment we've done towards the end of last year in the leaseback lease to specifically agree to an occupation date, lease commencement date. This is the date on which the lease will commence, and whether the tenant then takes the keys or not, he is entitled to. And that entitlement and that right of going to fetch the keys from the agent, whether he does or not, doesn't mean he's not in occupation. So occupation means I have signed a lease agreement as a tenant. The landlord and I have agreed that on the 1st of March 2021, I will take occupation of the premises. Whether I go and fetch the keys or not does not mean I am not in occupation or I am. If the parties agreed that the tenant has occupation from the 1st of March 2021, he has occupation from the 1st of March 2021. And in terms of most lease agreements, failure to take occupation is deemed to be a form of breach of the agreement. And you are allowed to place the tenant on terms and give him a certain period of time to take occupation, failing which you can cancel the lease agreement and claim damages from the tenant. If the tenant has the keys to the property, occupation is as easy as that to prove. The tenant has the right to take occupation, but he doesn't have to physically be in occupation to have occupation. And once the tenant has occupation, he is responsible to pay rent. And this brings me to the answer of this question. What is the effect on payment of rent if the tenant does not take occupation? It's the same as it would be if he took occupation. So if the tenant has to take occupation on the 1st of March 2021, and he doesn't come and fetch the keys, he doesn't take occupation, he is still responsible for payment of the rent because the right he has is sufficient for him to have the right of occupation, and he has to pay the landlord for the right he has. Whether he uses it or not doesn't really matter. It's sort of like, excuse my example, but bear with me. It's almost like um, a loyalty card. The fact that you are earning Discovery Miles or e-bucks or whatever the case might be, the fact that you're not using it doesn't mean that you're not entitled to it. And that is exactly the same with occupation. The fact that you have the right to use it, whether you use it or not, has no bearing on the actual responsibility you have to pay for the right that you are getting. That makes sense, because it's a strange concept. Very often tenants will sign a lease agreement, pay the deposit, not pay the first month's rent, not take occupation, and then say, but I never took occupation. I've decided not to go with this property. I'm sorry, Mr. Tenant, you signed an agreement. You are responsible to pay this rent, and you are responsible to take occupation. On the topic of occupation, who is the tenant? The tenant isn't necessarily the person in occupation of the property. A tenant is allowed to allow other people to occupy the property through and under him. This is not subleasing. I'm talking about a family member. Say, for instance, a parent renting a property for his child to live in. The parent will be the tenant, but the child will be the occupant. This is 100% allowed. It's not subleasing. Subleasing is where the occupant is then paying the tenant in return. And so basically getting the right of occupation completely from that party. That's not what it is. Occupation, and the person who is allowed to occupy may do so through and under the tenant, as long as the tenant allows him the right to occupy the premises through and under him. So occupation might not be the tenant. The person in occupation might not be the tenant. It could be a third party, as long as the tenant then has some or the other relationship with the occupant that will basically put him in a position where he has a right or an obligation to provide accommodation to this person. When it comes to maintenance, can a tenant withhold a portion or the full rent for repair or maintenance? Well, in strict law, yes, because we have a rule in our law of contract, the exceptio non ademptio contractus rule. This is basically a remedy to breach. What on earth am I on about? A remedy to breach means if a party is in breach, the innocent party has the right to elect a few potential remedies. For instance, a landlord that doesn't do maintenance to the property is in breach of the agreement, because a landlord has an obligation to maintain the property so the tenant can use the property, have undisturbed use and enjoyment of the property. If the landlord doesn't attend to the maintenance, the tenant can say, Mr. Landlord, you are in breach of this agreement. You need to remedy the breach within 20 business days if the CPA applies. If you don't, I'm going to cancel the agreement. Or, wait for it, I'm going to approach a court for a specific performance order compelling you to do what you have to in terms of the agreement. Or, in the case of exceptio non ademptio contractus, I am going to allow you time to remedy your breach. If you don't, I am going to withhold my performance until you perform. So I'm giving you 20 days to get your house in order. It's actually cute because it is the landlord's house. I'm giving you 20 business days to get your affairs in order and to remedy your breach. If you do not do that, I'm not going to pay your rent after that. I am going to withhold the rent, and I am going to attend to the maintenance with the money I am withholding, or I'm simply going to withhold until you perform, until you come and fix the things that you need to maintain. I'm not going to pay rent. In that case, it is legal and allowed. However, a tenant may never, ever, 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 ever just withhold rent and say, no, but it's because I had to do maintenance. If you do not follow the correct process, which is giving the landlord proper notice of your intention to act in terms of that bridge, you are not allowed as a tenant to withhold rent. If you look at your lease agreement, there are two options for a tenant to act against the landlord. Either clause 21, this is cancellation in terms of the CPA. You do not want to use that clause in this situation. You want to use clause 24, specifically saying if the landlord is in breach of the lease agreement, the tenant is allowed to give him 20 business days to remedy his breach, failing which the tenant may utilize whichever remedy that's available to his disposal. Caution. As a rental agent, you are mandated on behalf of the landlord. You cannot tell a tenant to act against the landlord. That is a conflict of interest and unfortunately unprofessional conduct. My recommendation is point out clause 21 and clause 22, clause 21 and clause 24 to the tenant at the time of taking the tenants through the lease agreement. Explain the difference between the two clauses and make sure that the tenant understands. And should this problem arise and the tenant say, well, I'm not going to pay rent, you need to tell him that he has to approach an attorney who will guide him through the process and do it correctly. You as the agent, mandated on behalf of the landlord, are not allowed to advise him to act against the landlord. Then again, use of the property, so occupation still is business or work from home allowed when you have a residential lease agreement. So in your lease agreement, you will clearly see under use of the premises, which should be around clause 5 or 6 of the lease agreement, you will see that the lease agreement specifically says the property may only be used for residential purposes and no other purpose. So what now if the lockdown regulations say we must work from home? Work from home and running a business from home are two very different things. You can work from home, but you are not allowed to run a business from home. My goodness, Silna, what is the difference? The difference is actually quite simple. Running a business will require specific zoning will have specific zoning requirements. For instance, in a sectional title complex, if somebody is running a nail salon, you suddenly have an impact on the people in the complex. More people are moving in and out on a 2-hourly basis to have their nails done. And it creates an issue on visitors' parkings. It creates an issue of potential security risks, things like that. There you need a specific zoning or at least agreement with the body corporate to be allowed to run a business from home. To work from home in the context of me having to move, half a law firm into my living room during lockdown, that's not running a business from home. That is working from home. That is definitely allowed, regardless of the zoning and regardless of the fact that your lease agreement might say that you are only allowed to use it for residential purposes. Setting up your laptop and your webcam to run meetings from home and to work from home, be on the phone, doesn't cause a disturbance to anybody around you and poses no risk to the landlord. Running a business from home is something completely different. If your business is basically like mine, something where you can do the work from home, it's not a problem at all. Running a business means customers in and out, clients in and out, or in the case of a lot of things I've seen in my life, like running a shop from home, it causes some problems. You need to be sure that working from home is allowed in a residential lease agreement. Running a business from home is not allowed unless the zoning allows for it and the landlord specifically agrees to that in writing. Then, access to the property. This is a good one. When may the landlord or the agent gain access to a property? It's actually quite simple. Your lease agreement will tell you. The lease agreement will typically say that the landlord or the agent are allowed to market the property 3 months prior to the termination of the lease agreement and are then allowed to have viewings, or in the case of the leaseback, a specific times where you are allowed to access the property for show days. For instance, 2 Sundays a month and a specific time. I specifically make provision for a show house from 12 o'clock on a Sunday. And the reason why I do that is you need that extra 2 hours before 2 o'clock in the afternoon just to create some form of order in the house. So there would be provisions like that. The rest of the time, the landlord or the agent are not allowed to access the premises unless it is agreed to in writing. The Act allows for reasonable access. What is reasonable? It means don't just rock up to the tenant's property. Make reasonable arrangements, usually around 48 hours prior to the visit, and you must have a reason for that. Either an inspection, a midterm inspection. A landlord is not allowed to have constant access to the property to inspect. You can inspect for renewal or any other inspections that the parties agree to in terms of the lease agreement. Because one of the essentialia of a lease agreement is that the tenant must have undisturbed use and enjoyment of the property. If the landlord or the agent randomly walks in and out at their will, it's not undisturbed use and enjoyment of the property, and it is not allowed. What's important is when you have an emergency, in terms of the leaseback, we do cater for an emergency where if there's an emergency in the sense of a fire or a flood, you are allowed to, when the tenant is not there, gain access by either getting a locksmith or whatever the case might be, depending on the type of crisis that is there. If that is the case and you had to gain emergency access to the property with or without the tenant's knowledge, and you had to, for instance, change the locks, it is a requirement that you provide the tenant with the change and the new keys as soon as humanly possible, so you don't accidentally lock him out. Yes, even in the case where the tenant hasn't been paying rent and there was an accidental fire, you need to make sure that you provide access to the tenant as soon as humanly possible. The rest of the time, unfortunately, the landlord and the agent cannot access the property and need to leave the tenant to be in peaceful, undisturbed use and enjoyment of the premises. But now what about a tenant refusing to allow access for potential buyers or tenants to view the property? Thing is, one of two options. Either place the tenant on terms in terms of the lease agreement. So say, in terms of this clause of the lease agreement, I am allowed to show the property to prospective buyers or tenants twice a month. This is what the lease agreement says, or whatever the case is, or on reasonable notice. You, Mr. Tenant, are refusing to allow me access to the property for this purpose. I'm giving you 20 business days to remedy your breach by confirming that you will allow me access, failing which I will cancel the agreement. Now, the truth is, guys, practically, that guy's not going anyway. The reason why I'm saying this is, if somebody is not performing in terms of the lease agreement, why on earth would he now suddenly be bothered if you cancel the agreement? The statistical chance of us having to evict that tenant is pretty high as it is. So what you do, you can approach a court on an urgent basis, depending on the reason why, if you have urgency, for instance, I need to have a potential seller view a potential buyer view the property, and if we don't, there's going to be a problem because we might lose that buyer. Not grounds for urgency. Grounds for urgency can never be commercial urgency. You have to be able to show that there will be irreparable harm if the court doesn't hear the matter on urgent basis. So the only time where you will have success in approaching a court on an urgent basis to gain access is if, for instance, the property is flooding and the people are in occupation and they don't want to open the door or something like that. It's going to be a weird story for us to be successful with an urgent application. Unfortunately, the only option you will have when a tenant refuses to give access would be to either wait it out for the lease agreement to come to an end and hopefully the tenant vacates. But on that topic, my advice is anyway not to force a tenant to give you access, because when you then do bring potential buyers or tenants around, they're not going to be pleasant and they're not going to really encourage these people to take occupation. The truth is, if a tenant refuses access for viewings, the statistical chance of us having to evict that tenant is pretty high. And for that reason, my recommendation is usually not to force access, but to wait for the tenant to vacate, because the problem is, if we foresee a potential eviction, I would never, ever, ever recommend that you sign up a new tenant, because if you then can't give him occupation, even though the lease agreement does provide for a landlord to not be held responsible for that, it would only be in circumstances where the circumstances why the landlord can't give occupation is effectively out of his control. Where if you foresee that there's a problem and a potential eviction, and the landlord still signs a new agreement, he could end up with a damages claim from the second tenant that can't take occupation. So be careful. My advice is not to force access, but to wait for the lease to come to an end. Yes, the landlord will then have a vacant premises for a month or two because you couldn't show the property to potential occupants. But the truth is, the risk and the potential success of getting a tenant anyway, when the exiting tenant refuses access, is anyway slim to none. This is an exception to the rule. In most cases, tenants will allow access. So in a few cases where it's a problem, contact an attorney with the specific details of that lease agreement. And I advise the landlord then to instruct an attorney to do specific letters to the tenant, and not for the agent to try and wing it here, because it could end up blowing up in your face pretty impressively. So what I'm saying is, the answer on the tenant refusing to give access is give it time and wait for the tenant to vacate. If he doesn't vacate, we anyway need to evict him, which means access was the least of our problems. It's vacant occupation that's now currently the problem. So I hope that answers that one. It was so much fun to be with you guys today. I think we've covered quite a few sticky points and sticky areas. I'm sorry that on some of them I had to say, well, sorry, there's not much you can do but wait. But I would rather know that you know exactly when to take action, when to advise your client to approach an attorney for legal advice or for legal intervention, and where it's actually wiser to just sit back and wait it out. But as always, you guys are more than welcome to give us a call, talk to us. On our website, there are articles for days, lovely bedtime reading, which will cover most of the questions you might have in a lot more depth. You're more than welcome anytime to use those articles, send it out as answers to your clients. And obviously on SSLR's YouTube channel, quite a lot of handy videos and things that might be helpful. And if you have a sticky point, more than welcome to contact us. I think most of you are used to us. I promise we don't charge if you ask a quick question. Only once we need to take instruction, peruse documentation, something like that, will we charge, but we will quote in advance. So please don't suffer in silence. Talk to us. Let us help you. And I hope that you're going to have a lovely February and beginning of March. And I will see you back for the training session in March, where we're going to be discussing the rental housing tribunal, how it works, and what we're going to do in the tribunal. And if you have to go to the tribunal, what should you know and how should you handle it? But I hope it was a fun start to the year, and I'm looking forward to the rest of the training sessions for 2021. I do hope that you're going to have a lovely day, and please stay safe.